Hello, everybody. Good morning. This is a matter of Campbell versus Campbell, case number 24-10930-DM. Present in the virtual courtroom, we have both parties along with their respective attorneys. We're here on the plaintiff's motion for a temporary order. Ms. Boldish-Bryan.
Thank you, Your Honor. As you know, and I know that you read our motion as well as the response, my client Danielle works part-time. The parties have one child, a 2-year-old. My client is 34 weeks pregnant. The baby is due in early January, so about 6 weeks from now. The father is a lawyer at a large law firm in town, a very prestigious law firm. There are two things that we wanted to say in response to the answer filed by Mr. Campbell. The first thing is that Danielle very much wanted to save the marriage. She didn't want to leave the marriage, even though he describes the divorce as being a mutual decision. It was not by any means. His response indicates that the parties fell out of love, and in her view, she didn't fall out of love. This is a situation where he simply left the marriage unilaterally. She asked him repeatedly whether he had an affair. He repeatedly lied to her and told her that he was not involved with anyone else. We did learn through use of a private investigator that he was involved with an affair and that his regular practice was to leave the house early in the morning, 6 o'clock, 6:30. He would leave the marital home. He'd go to the home of his girlfriend. He'd stay there in the dark for several hours. And then he would go from there to work, which was, of course, contrary to what he represented to his wife. This was important to the court because we hear him now talking about his involvement with the child. Nothing could be further from the truth. He preferred and he took efforts to spend time with his girlfriend rather than the child. He did this not only in the morning, but also in the evening and also on the weekends. The second thing that we wanted to respond to is with respect to his claimed involvement with the child. My client has been able to recreate some information for me using texts from him as to where he is, whether he's working or not, based on her recollection. For example, in July, he only spent a handful of hours with her. That did increase in September to about 2 hours a week. In mid-September, he started picking her up from daycare. But the reality is that he was working, ostensibly working, on a regular basis and not returning home until the child was in bed. November 7th was the last time he even attempted to give EJ a bath. And so if you think about that, that's been several weeks since he even attempted to. It was a disaster. Child was screaming, regularly expressing preference to being with her mom, which is not of any surprise given his regular absence. It is true that he took care of EJ for a weekend in October, and I don't know how well that went, but the reality is that right now, he wakes up in the morning. Now he's hanging out a little bit more. He kisses EJ in the morning and then goes off to work. Last night, he spent 3 hours with her from 4 until 7. He comes home. The child immediately runs up to mom. She's crying. He had not changed her diaper. Child has a rash. Mom is trying to take care of that, does her routine. Dad is not anywhere around. He sings songs. She reads books. Again, dad's in the house, but not anywhere around. Finally, he shows up, kisses EJ goodnight, and he leaves. And then mom is left with a process of putting her down for bed. So he leaves before she even goes down to bed. Our request, Your Honor, is that clearly mom is the primary care provider of this child. I appreciate dad's attempts to become more involved recently. We're glad for that. We think that a transition is appropriate in the facts of this case. We are suggesting that he move out immediately and that he begin and try alternate weekends that would include one overnight, which would be an alternate Saturday. And then additionally, with regard to his parenting time during the week, that he have Wednesday afternoons, something such as 4 until 7. I want to point out that this is more time than he has historically ever had with this child. Mom should be awarded physical custody. That's what the facts show, despite his claim that he has a new pattern of taking care of the child. That is absolutely not correct. We are also asking for immediate exclusive use of the marital home. The situation here is quite unique given my client's pregnancy. She's 37 weeks. This has been enormously hard on her, a very, very difficult burden. And it's not made easier by the fact of dad's practice right now to basically come in, kiss or see the daughter, and then he slams down a glass of whiskey and heads out for the evening to spend with his girlfriend. This has been very, very hard on her. He is very, very bold with regard to his relationship with his girlfriend right now. The good news is that his father has a lovely home, very lovely home, many bedrooms. He can go there immediately. Apparently, there's even a crib there. There's a high chair. It's already set up for the child. I understand that is not a long-term preferred residence for him, but it seems as though he's spending most of his time with his girlfriend anyway. So he's really looking for a temporary arrangement where he can take EJ. We would ask that he be ordered to move out of the house on Sunday. This wouldn't be the situation where he has to take all of his things out by Sunday, but he can certainly pack this weekend his clothing and personal items, move into his dad's house, and stay there temporarily until he finds longer-term housing. He has told Danielle that he's located an apartment that would be available December 1. I don't know if that is still available for him, but that is an option for him for a few days. But we would implore the court to ask that he leave the house and give her exclusive possession as soon as possible. I wanted to note that in a conversation that Danielle had with Mr. Campbell recently, she said to him, "Are you going to at least apologize for what you did?" And he said, "For what?" And it is this type of arrogance that is creating significant emotional distress for my client, which absolutely impacts the health of the unborn baby. So we need to end this now and have him move out on Sunday. With respect to the financial situation, the good news is that if you order the exclusive possession, which I expect for you to do, then we have agreed upon the terms of a status quo order, and so we don't need to address the financial situation right now. This is a very unique situation because when Danielle has the baby, she doesn't have the benefit of any maternity leave, so she has no income. That would be effective, I think, at the last week of December is when she's leaving her job for her maternity leave. So our request today, Your Honor, is that she be awarded physical custody, that the parties share legal custody, that we begin transitioning dad's parenting time for one overnight on alternate weekends and Wednesday evenings from 4 until 7 p.m. And then finally that he move out and that Danielle be granted exclusive use of the marital home effective Monday. Thank you.
Ms. Judd.
Thank you, Your Honor. Well, as the court can gather from the argument here and from the pleadings alone, the disparity of fact in this case is pretty significant. Is he in the house pounding whiskey and not around, or is he gone having an affair? This seems to be a little bit of a moving target, but as this court knows, simply because we have an oral argument about the history of the parenting time in this case doesn't make it a reality. And my client would wholly disagree with the recount today of the history, which I've outlined in the pleading that I filed. I can certainly respect that the sympathies here lie with the plaintiff, But the inflammatory allegations about my client being a cheater and ending the party's marriage, even if they were all true, don't undermine the reality that he is a good father, as plaintiff herself has acknowledged in text messages to my client. My client would reiterate here that this marriage, again, was over quite some time ago, and he believes that Ms. Campbell knows this. Her position seems to have recently shifted when she advised my client that she would go to any ends necessary to make sure that he played as limited of a role in this child's life as possible, as well as the future child of the parties. This really is an unfortunate position that I hope is short-lived, but based on the recent allegations and the pending discovery that we have now, I fully anticipate that this court is going to be quickly placed in the position to weigh in on how much of a smear campaign is appropriate as leverage in a parenting time matter. My client shouldn't be placed in a situation where he has to gamble with job security and threats to his personal relationships with friends and family just because he wants to continue playing an active role in this child's life. Plaintiff herself has acknowledged the hurt for both parties in this relationship. I get that. She's further affirmed that the minor child is what matters. That text message was attached to my response. My client is sad too for the current state of the parties' relationship, and he wants nothing more than to keep this case limited to their child. But to that end, he is a dedicated and actively involved father, and he has no intention of being bullied into decreasing his parenting time with the minor child in exchange for leaving or any of that. There are no circumstances in this case. There was nothing attached to the motion. The only thing here is plaintiff's own desire to have him removed from the house immediately leading into the holiday season. I mean, come on. There's no circumstances, even alleging abuse. There's nothing. But without backing himself into a corner here, like Ms. Bryan suggested, he is willing to leave. He is happy to volunteer to vacate the home with the understanding that the temporary arrangement be preserved between the parties. He's happy to afford Ms. Campbell an expectation of privacy, but the understanding here would be that the status quo be preserved. My client is absolutely able to verify his position with regard to the status quo, with regard to the parenting time arrangement, and far more text messages than were included in my little sampling attached to the response. So I would request, if the court is inclined to do anything here other than maintain the shared caretaking arrangement that I had outlined and affirmed in a couple of text messages as a sampling, that we do a prompt and brief evidentiary hearing so as to demonstrate what the actual custodial environment for this child is before we enter a new order. He's had full weekends with the child alone, without issue, multiple weekends, not just one. He's regularly put her to bed during the week, admittedly, and is verified by Ms. Campbell's own correspondence. There haven't been issues with this. There aren't temper tantrums. There's no evidence of any kind of that. In fact, there's quite the contrary. If you skim the messages that I attached, there's affirmation that EJ is looking forward to seeing him, and she adores her time with him, and she's going to have a wonderful day with him, and has. But what's being proposed here is a drastic reduction from what the parties have been following. And more importantly, it's a drastic reduction from the schedule that's affirmed in Ms. Campbell's own correspondence to my client. Like I said, the ask here, consistent with the statute and the corresponding case law, would be a prompt and brief evidentiary hearing to demonstrate what the custodial environment is prior to making a drastic modification to it. And like I said at the beginning, the parties' allegations here really couldn't be further apart. But worth noting again is the reality that there's no evidence here to support Ms. Campbell's position, aside from the newly created calendar that was mentioned today. I have no evidence from this alleged PI. I have nothing. I have nothing aside from this oral argument to try and recreate history. So while I can very much see that Ms. Campbell is trying to blame my client for this divorce proceeding, it is wholly inappropriate to incorporate this minor child as leverage in that attempt, especially given her regular acknowledgement that Mr. Campbell is a wonderful father to her. Yes, he works full-time. Yes, he's moved on with his personal life and his own personal time that has been designated by the parties themselves as his personal time. but he has consistently prioritized his time with his child and very much wants to continue doing so. He has every intention of continuing to do so after the parties physically separate. He would absolutely maintain the position that he has served as a joint custodian to the party's child, and he only asks this court that he be permitted to continue doing so, consistent with the parenting time schedule that the parties themselves came up with and have been following quite literally for months. The comment about recently starting to pick the child up at daycare is significant because I would note again for this court that the child recently started daycare. She had an in-home nanny and her daycare didn't start until September. So yes, of course, he recently started picking up the child from daycare because it wasn't an option before. But the manipulation of facts here in an attempt to make him look like he has a selfish agenda is simply not accurate. So I would very much hope that the court would at least afford some additional time to get to the root of this established custodial environment if it's inclined to do anything aside from memorializing the shared caretaking arrangement. Thank you.
Ms. Bryan.
Your Honor, the shared caretaking arrangement is 1 hour on October 15, 1 hour October 17, 1 hour October 22, 1 hour October 24, half hour October 29. A few hours on a weekend here and there. He leaves early in the morning. If Attorney Judd wants to confirm that with her client, she could ask him that. He leaves early in the morning. He goes over to his girlfriend's. He's not there in the morning because he's with his girlfriend until the divorce case gets filed. And then all of a sudden he's hanging around a little bit more in the morning, kisses EJ in the morning, and then takes off. Now, the evening and what happened last night is not indicative of this great relationship that Attorney Judd claims that father enjoys with the child. The child runs up to mom. He didn't change her diaper, and he doesn't even stay around for the bedtime routine, instead preferring to exit before she even goes to bed. That is the facts of this case, and he can't get around it. So the reality here is that this case is not any different than what you hear on a Friday morning motion. We need to make a decision. I think it's clear based on the evidence the court has thus far that mom is the primary care provider for this child. She enjoys a close emotional attachment. She works part-time. She's devoted her life to this child, and father has devoted his time to his career and to his paramour, not to the child and certainly not to Danielle. I'm glad to hear that Mr. Campbell's willing to move out. We would ask that it take place immediately. He hasn't moved out until now because he's trying to use it as leverage. But this is extremely painful for my client under the circumstances to see him exit every evening and head out to see his girlfriend, and then returning late at night, early hours of the morning, or whatever it might be. So we would ask that the court grant physical custody to mom and grant our relief and request with respect to parenting time. And this could be reviewed when we come back to the court for, settlement conference. So we could refer this to front of the court as well. Thank you.
Thank you. Well, based on both the written submissions of the parties as well as the argument today, it appears to the court that due to a number of factors, including the parties' relative work schedules, that the mother in this case does have the established custodial environment. That doesn't mean that father's not a good father. It just means that she is most likely the primary parent in this case, at least based on what I have today. So I will grant sole physical custody to the mother, joint legal custody of the parties. Parenting time would be alternating weekends with 2 overnights, and Wednesday evening or afternoon from 4 to 7 p.m. It sounds like the parties are agreeable to a status quo order regarding expenses, and the defendant is to leave the marital home on Sunday, November 24th, 2024 by 5 p.m. And after that point, the plaintiff is granted exclusive use.
Thank you, Your Honor. I'll prepare the order.
And
Your
I
Honor.
will refer this to the front of the court for an investigation regarding custody, parenting time, and child support, and the parties are to split the fees.
Your Honor, I have a couple of clarifying questions, and then
Sure.
I did request a mutual civil restraining order in the motion. I assume the court has no problem with that.
I don't.
Okay, and then I guess I'm a little confused as to why my client wouldn't be permitted to continue a midweek overnight, especially if he is warranting that he has sufficient overnight accommodations. I also wonder if there could be a little bit of an additional time window on the exclusive use. Ms. Bryan herself indicated that for some reason her client believes that the place is available on December 1st. My client's father's home does not have a sufficient situation for him to immediately move into and have the same level of space there as a residence of his own would. So I would ask for a little bit of an additional amount of time for that. I'm not really clear here as to what the circumstances would suggest that we get 2 days, but that seems a little bit unorthodox, respectfully. I would ask for a little bit of an additional time window here if that's an option for the court.
Well, as far as that goes, this is an unusual situation. I am taking into consideration the plaintiff's pregnancy and the fact that she's late in her pregnancy with the party's child, and the additional stress that this is causing. So I'm going to deny the request to extend that time. I see no reason why it couldn't be Sunday. And again, it's not a complete move out. As far as having to, divide up personal property, just sort of take your clothes, the things that you need, and then we can work out the rest of it going forward. And then as far as the Wednesday, I will allow an overnight for Wednesday.
Thank you, Your Honor. I appreciate that very much.
All right.
So we'll do the Friday daycare pickup, or I'm sorry, she's with Miss Campbell on Friday. So Friday, 4 p.m. start until Sunday. Is there an end time that the court would dictate here?
I think
What
he
time?
goes to bed at 7:30, I think. So would
7
6
p.m.
o'clock be all right?
6?
6 p.m. Is that what the court indicated?
I think so. Is the child's bedtime is 7:30?
I think that's correct. Danielle, can you nod your head? Yes, I think she
Okay.
said.
All right. I think 6 o'clock is appropriate for return.
Okay.
And then, Your Honor, with respect to the civil restraining order, I'm looking at her response. I don't see the request for the civil restraining order. I just, the whole issue here is how would that read? I think what Attorney Judd and I have discussed and what we've had a problem with is that we agree that neither party would disparage the other in the presence of the child or within hearing distance of the child. That makes sense to me, but I think he's trying to prevent her from having contact with her friends, some of whom work at the law firm where he is, and she should have free contact with him and be allowed to share, what she wants. I mean, they've reached out to her and are supportive of her. So what is the extent of the civil restraining order that the defendant requests?
Ms. Judd, do you want to fill me in on that?
I would disagree that she has friends that are close confidants at my client's place of employment. I think it would be appropriate to include a general non-disparagement clause as well as a restriction from interfering with either party's place of employment. I think that would be sufficient. I mean, my client's partners don't need to be hearing about this and wondering what's going on. I don't think that's appropriate. And I think that Ms. Campbell presumably has additional people she can confide in if she needs to vent about Mr. Campbell.
She's not had any contact with his partners, nor would she interfere with his employment, but this is a court order. So I don't want to have some kind of misunderstanding that if she has a communication with a friend or supporter who's at that law firm, that's viewed as being disparagement.
I think it needs to be narrowly defined. I don't want to hash it all out right now because it doesn't appear to be a subject of the motion, but I'll leave it to the attorneys to work that out. And if you can't, you can ask for a case conference with me.
Okay,
All right.
wonderful.
Okay.
Thank you, Your Honor. I'll prepare the order.
Okay, wonderful.
Thank you.
And we'll take
Have a
care
nice
of the referral to the front of the court.
Okay, thanks
All right,
very much.
thank you.
Okay, we're adjourned.
Be safe, be well, sleep sweet, and much love.